The subcommittee will come to order, and let me express my apologies for the lateness in starting. We did have a series of votes. Who could ever anticipate or predict? So again, I want to say how unfortunate it is for that almost hour-long delay, but thank you for your patience. I'd like to welcome all of you to our fourth oversight hearing this year on implementation of the Sean and David Goldman International Child Abduction and Prevention and Return Act. The Goldman Act empowers the executive branch with powerful new tools and a myriad of ways to successfully resolve parental child abduction cases. Like any law, however, it is only good as its implementation. Historically, some 750 to 1,000 American children are unlawfully removed from their homes each year by one of their parents and taken across international borders. International parental child abduction rips children from their homes and takes them away to a foreign land, alienating them from the love and care of the parent and family left behind. Child abduction is child abuse. Its negative impact on the child and left behind families can last for years, even a lifetime. Two of our witnesses today, like many in this hearing room and around the country, know firsthand the trauma, the tears, the excruciating pain, and the longing and heartbreak of a parental child abduction. David Goldman, son Sean, was abducted to Brazil and unlawfully retained for approximately 5.5 years. Mr. Goldman tenaciously pursued every legal means of return, including expert legal counsel, in his quest to bring Sean home. Today, father and son are thriving, and we will hear from him in panel 2. Captain Paul Tolan continues his heroic 12-year quest to bring his 13-year-old daughter, Erica, home from Japan. Captain Tolan refuses to quit or to be deterred despite years of frustration and setbacks. Such is this father's incredible love for his precious daughter. Our first hope, of course, is to prevent or at least mitigate the number of child abductions, and the State Department is to be commended for implementing a provision of the Goldman Act and for taking other efforts as well, including the one that adds children that a judge has determined to be at risk of abduction to a no-fly list. In 2014, we saw a decrease in the number of new abductions, 150, as a matter of fact, fewer cases than the previous year. And I want to do a shout out to Rush Marburg on the prevention side, who has done a magnificent job in this endeavor. But I am frankly concerned that the State Department has chosen not to impose any sanctions on any of those nations found to have engaged in a, quote, pattern of non-compliance. The Goldman Act, however, requires the State Department action on individual cases that have been pending for more than a year if the foreign government has not been taking adequate steps to resolve the case. The Goldman Act also requires action when collectively a country has a high number of cases, 30% or more, that have been unresolved for over a year, or if the government is failing in their duties under the Hague Convention or other bilateral agreements, or if their law enforcement fails to enforce return or access orders. The Goldman Act not only shines a light on a country's record through annual designation of countries showing a pattern of noncompliance, it holds countries accountable and hopefully incentivizes systemic reform. Actions, as we know from the law, escalate in severity and range from official protests through diplomatic channels, to public condemnation, to extradition, to suspension of development, security, or other foreign assistance. The Goldman Act was designed to raise the stakes on the foreign country's inaction or obstruction and move that country to end the nightmare of child abduction. In July, we received the State Department's first annual report on abduction and access resolution rates around the world. The annual report had some major gaps and misleading information, some of which were corrected by the supplemental data posted by the State Department in August. Tragically, in contravention of both the spirit and letter of the Goldman Act, the State Department failed to list Japan, with more than 50 abduction cases among the 22 countries showing a pattern of noncompliance and therefore eligible for Goldman Act sanctions. This glaring omission, which can still be corrected today, sent the unfortunate signal that pre-Hague Japan cases were not a top priority. Cases like that of Sergeant Michael Elias, who has testified here. He's a New Jerseyan who has been denied any contact with his 2 children, Jade and Michael, after they were abducted to Japan in 2008. In September, the State Department sent to Congress its first 90-day report on actions it took to bring the 22 countries most to the resolution table. Those actions including demarches, judicial rulings, meetings, I should say, and education efforts and meetings, all of which are necessary and of real value. But noticeably absent was the imposition of any number of meaningful sanctions, again, prescribed by the Goldman Act. I respectfully submit that this was a missed opportunity to convey to pattern of noncompliance nations that the United States is absolutely serious about resolving parental abduction. The imposition of sanctions says we mean business. And I would note parenthetically that sanctions, and I've done this in other laws that I've written, including the Trafficking Victims Protection Act, but also our Civil Rights Act. Title IX, which has made all the difference in the world in women's sports, always carried a penalty phase, and that certainly got the attention of universities and colleges throughout the country that the federal government was not kidding and wanted changes in how these universities did business. Notwithstanding Section 103 of the Goldman Act, the report makes no mention of MOUs or bilateral agreements to resolve cases, including and especially cases that existed prior to Japan's ratification of The Hague. I and many others have raised this concern for several years. I actually did it on a trip to Japan with Michael Elias's mother, the children's grandmother, and said if we don't get that right, they will be twice left behind because they are less likely to find themselves a resolution to their cases because, of course, the Hague Convention is from the date of ratification onward. It does not have a look-back provision. The report details the State Department's effort to persuade India to ratify the Hague Convention, a step that, if not combined with an MOU to resolve current abduction cases, which number about 75 today, risks duplicating the extraordinary misery endured by left-behind parents after Japan ratified The Hague. If India ratified The Hague, it will, like Japan, grandfather pre-existing cases out of the convention resolution process. I would note that Bindu Phillips, who has been here, and she too has testified, mother of Albert and Alfred, has struggled with her ex-husband in Indian courts for the return of her son for nearly 9 years. 9 years. And every time she thinks she may be on the verge of a win in court, obviously there's always, like in David Goldman's case, another appeal to bleed her dry financially and to make it difficult to ever get her sons back. Ravi Parmar has been fighting for his sons returned for 3 years. Section 201 of the Goldman Act also requires the State Department to conduct a review of individual cases pending 12 months or more to discern whether the foreign government has taken adequate steps to resolve the case or whether actions are warranted. This individual case trigger for actions, as opposed to the pattern of noncompliance country trigger, despite a half-dozen congressional letters from various members of Congress asking for Section 201 reviews of egregious cases, the state, to my knowledge, has not done a single review, and perhaps, Ambassador Bond, you can enlighten us on that. I am encouraged by a press statement issued today by Secretary of State John Kerry, in which he says clearly that he is looking to use all of the tools that have been prescribed by the Goldman Act as the beginnings of the next report take place. And he said, you know, in his press release, and I do have it, he says in his press release, and I think it's a very important point, that there can be no safe haven for abductors. The State Department, Secretary Kerry says, will continue to use all the tools available to us to help those involved in international parental child abduction cases to resolve their disputes and move forward with their lives. So that is a very encouraging note. Now I'd like to introduce Secretary Bond, first with a very brief introduction, and without objection, your full resume will be made a part of the record. Ambassador Michelle Bond serves as Assistant Secretary for Consular Affairs at the State Department. As Assistant Secretary, Ambassador Bond leads a team of 13,000 consular professionals in almost 300 locations across the U.S. and around the world who protect the lives and interests of U.S. citizens abroad, facilitate legitimate international travel, and helps protect our nation's borders. A career member of the Senior Foreign Service, Ambassador Bond has more than 38 years of diplomatic experience in Europe, Africa, and Latin America, including having served as U.S. Ambassador to Lesotho. Ambassador Bond, the floor is yours.
Thank you. Chairman Smith, thank you for this opportunity to discuss international parental child abduction. This is one of the highest priorities of the Bureau of Consular Affairs and the Department of State. As Secretary Kerry noted in his statement on child abduction yesterday, and as you have pointed out, the Department will continue to use all the tools available to us to help those involved and to resolve their disputes, move forward with their lives. Mr. Chairman, thank you for your leadership on this issue. You have heard the testimony of my colleagues, Ambassador Jacobs, Deputy Assistant Secretary Christensen, and Director Hand in previous hearings. You know that I lead a talented team of experienced professionals who work tirelessly to prevent abductions and bring children back home. My testimony today will summarize my written statement, which I request be entered into the congressional record. The Sean and David Goldman International Child Abduction Prevention and Return Act of 2014 has given us additional leverage to resolve these cases. We have already put these additional tools to good use. We're proud of our contribution to the 247 returns in 2015 and about 140 prevented abductions in 2015. And we recognize and accept the challenge of the 1,100 cases that remain open, some for many years. Mr. Chairman, many actions take place every day to prevent or resolve these heart-wrenching cases. Since implementation of the law, more than 140 children have been protected from removal from the United States. The law also provides the mechanism to streamline interagency efforts, and we are fortunate to receive crucial assistance from our interagency partners. We share your goals of preventing abduction, ensuring the expeditious return of children to their homes, and strengthening and expanding the Hague Abduction Convention. Let me briefly explain the role of the Office of Children's Issues within the greater context of how the Bureau of Consular Affairs advances U.S. foreign policy. The Office of Children's Issues provides policy guidance and coordination within the Department of State and the Washington interagency community to prevent child abduction. It safeguards the welfare of abducted children, returns abducted children to their places of habitual residence, and helps parents resolve these complex cases. The Office of Children's Issues executes U.S. obligations under the Convention as the U.S. Central Authority. It leads U.S. government efforts both within the Department and with other U.S. government agencies to assist children and families involved in abduction cases in all countries, and reviews applications to partner with countries that have acceded to the Hague Abduction Convention. My Bureau leads the effort to engage governments on convention implementation, acceding to the convention, and providing assistance to families involved in cases in non-convention countries. Our number one priority is the safety and protection of U.S. citizens overseas. This provides little solace to those parents who are still waiting to see their children returned home. Only the safe return of their children matters. As a parent, and as an Assistant Secretary of State for Consular Affairs, I pledge that my team and I will continue to work to resolve all abduction cases. That includes working with convention countries such as Japan to resolve abductions that occurred before our partnership under the convention took effect. We are actively engaged with Japan in these cases. Disappointingly few have been resolved with the return of an abducted child to the United States or through meaningful parental access. My colleagues in the Bureau, throughout the Department and at our embassies and consulates abroad, press our foreign government counterparts on the issue of abduction and raise your constituents' cases at every opportunity. For example, we have requested the government of India's assistance in resolving reported abduction cases. Special Advisor for Children's Issues, Ambassador Susan Jacobs, Principal Deputy Assistant Secretary for South and Central Asian Affairs, Ambassador William Todd, and I all personally urged India to resolve reported cases in recent meetings in New Delhi and Washington. Additionally, officials at the U.S. Embassy in New Delhi are in regular contact with Indian Foreign Ministry officials on these issues. Mr. Chairman, let me again emphasize my personal commitment and my Bureau's dedication to prevent parental abductions. The Department of State and our interagency partners are committed to the implementation of the law and to safeguarding and returning abducted children to their places of habitual residence. We are committed to ensuring parents have effective tools to resolve these cases in both convention and non-convention countries. As always, I appreciate your interest, your feedback, and your suggestions. I look forward to your questions.
Thank you very much, Madam Ambassador. We're joined by Vice Chairman Mark Meadows. Do you have any opening comments, Mark? Okay, thank you. Let me just begin with some questions. First, in 2014, 18% of the left behind parents have to overcome when litigating for the return of their child in a foreign country. What sorts of obstacles, I should say, have they had to overcome? 18% of the 1,467 cases this year were resolved with the child coming home, and this includes resolved and unresolved cases, 18%. Of the 781 cases that were resolved, only 34% were resolved with children returning to the United States. In my opinion, these are staggeringly low numbers. Are you, Madam Ambassador, satisfied with this return rate, actual return rate, not resolution, where, as you know, there are criteria for closing a case, but obviously a return is something we're looking to break out and hopefully effectuate. And what are you doing to change that rate in 2015? Again, the return rate I'm talking about.
Mr. Chairman, I am not satisfied with that return rate. And we are working with each of the countries where there is a single case in order to address and identify what more could be done to actually bring each individual child home. As you know, these cases are not identical in any way, and so we are focused on working with countries on the pattern of how they deal with these cases, how expeditiously and to what degree of well-informed approach they have among their law enforcement, in their central authority, in their judiciary. We're working to make sure that people understand the point of the convention, the goals of the convention, how it's supposed to work. And we are investing a great deal of resources in the training and the exchanges that do, as we have seen through the years, that do lead to results in terms of better performance.
Can I ask you, obviously the report will come out late April. It'll be the second report. And frankly, when we saw the first trafficking in persons report, there was some threadbareness to that one, which was greatly improved when report second year, third year, fourth year came forward. And my question is, when it comes to the sanctions part, a lot of notice has been given to countries that are non-compliant. The conversations, the trainings, I think, are extremely important and can change hearts and minds, and that's important. But at the end of the day, if they persist in these patterns of non-compliance and are obtuse to the heart cry coming from abducted children and their left-behind parents, are you planning on hopefully applying sanctions in this next round? They begin, like I said, a lot of ample notice that it's in the law. I'm sure you and others have conveyed that in your conversations, that this is a sword of Damocles that hangs over them. We don't want to do it. We don't want sanctions. But if the record requires it, they need to be imposed. Are you looking for that kind of evolution in terms of the imposition of sanctions in round two?
The actions that are described in the law are, as you say, you have described them as a range that starts with a démarche and builds to. I would argue that the fact is that there's a lot of strength in reiteration. There's a lot of strength in continuing to raise an issue in order to emphasize how important it is to us, and to raise it broadly, so that individuals, it's not just, say, the Minister of Justice or the Minister of one or two foreign affairs that are hearing about it, but that a broad range, business people and others are getting the message that this problem exists because many people don't know about it, and also the nature of the resolution that we are proposing that the different countries follow, so that people understand what it is that we're talking about, what it is that we're asking for, and what it is, in the case of convention countries, they have agreed to do. There is a period of time, and it happened in the United States too, during which you are trying to make sure that people understand exactly what this treaty requires. And as you may know, in the United States, every time there is a child abducted here, a packet of information is sent to the judge who's going to hear that case, because most of the time, here and in other countries, a typical family court judge may never hear a Hague Convention case. And if he or she does hear one, it may be the only one they ever hear. And therefore, it's important to make sure that they understand that this is different from what they're used to doing, which is handling custody decisions. So the engagement that we have, and you've said, and of course I agree, that the education efforts are important. They're really fundamental. If you take, as an example, the countries where our principal problem is with the judiciary, those, in many cases, may be countries where we used to have problems with the central authority and now have developed strong, excellent, even communication and coordination and understanding with the central authority, but we're not seeing the results that we need in terms of prompt, focused understanding of what a Hague Convention court case is. And so in that case, the focus has to be on the judiciary and on making sure that the judges understand what the law is and understand how to apply it, understand that this is not a custody decision that we're talking about, it is a jurisdictional one, and so forth. So that's where the attention is focused if the issue has to do with judicial understanding and compliance with the law. If the problem in a particular country has to do with enforcement, and we have countries like that where the judges are making what we consider to be very good decisions, and then we don't see the enforcement of the return, there then you're focusing your attention on the people who are responsible for that. In almost every case, it's important to be doing a lot of public outreach and a lot of looking for ways to highlight this issue and the importance of it in the press, again, in order to get understanding and acceptance among the public of what's going on, so it doesn't look like their children are being taken to another country. So all of the actions that are suggested in the law are absolutely on the table, and the countries that we're talking to know that. The fact is, though, that the focus is on who is it that is creating the problem here? Is it judges not knowing what to do? Is it law enforcement not being directed to pick the kids up and arrange for them to get on a plane and come home? And you focus on that, on the people who aren't getting it, and finding ways to get them to do their jobs better. So I can tell you absolutely honestly and clearly that there are no actions that are not on the table. But the focus is on the actions that are directed at the problem that we see in a particular case or broadly in a particular country in order to turn that around. And again, I would say that there are a number of countries where we used to have real problems with the central authorities, and now we have very, very good understanding with the central authorities. So it is a fact that the efforts that have been made over the years do have an effect.
Can I just ask you again, we had the same issue dealing with the Trafficking Victims Protection Act, and when we said prescribed minimum standards, we often found that law enforcement was the weakest link because they were often complicit at the local level with the traffickers in the abuse. But we held the entire government, because they are part of the government, even though they are independent and judges even more so, to task. And Tier 3 would be meted out if there's a country where there's all kinds of collaboration with the traffickers. And I would argue that we're dealing with very smart people. Our interlocutors in Brazil, in Japan, in India, these are some of the most educated people that you're on the other side of the table that you speak with. They will understand to a great extent if sanctions are forthcoming. One of the biggest lessons I learned on trafficking was when Israel and South Korea were designated Tier 3. We don't have any better allies. We have similar and as good, but no better allies in the world than Israel and South Korea. George Bush put them on Tier 3. They could have lost security aid, economic support, but especially security aid, and there was a very serious contemplation. I have never seen two governments alter their behavior, crack down on the brothels where trafficked women were. In the case of South Korea, they passed some remarkably effective laws to end human trafficking there. And the trigger was the placement, followed by the very credible threat that those sanctions would be used. I would ask you, plead with you, use the sanctions. Pick out some countries, Japan certainly, and I know there's a reluctance to single out Japan. First and foremost, put them on the pattern of noncompliance, and maybe you can do that today. But certainly, if things don't change, and maybe if you could answer this question, if you made the designation today, based on the 50-plus cases, would you make that designation a pattern of noncompliance for Japan?
So I want to be sure I understand the question. Japan is absolutely a country that they have made a good start after joining the convention. We think that they have made a good start. We are watching very closely to see what they're doing this year with cases under the Hague, the convention cases, and they will certainly be cited if they're not performing. We're also very focused on the cases that were pre-Hague, but under the description, the requirements for the report, those didn't get reported in April. So that doesn't mean they're not important, and it doesn't mean we're not focused on them. As for the question, we've seen examples of countries who are responding exactly as you're describing Israel and South Korea having done, in terms of writing new legislation and looking at new ways to address problems that we were pointing out to them and pressing them to resolve. And so Slovakia is an example where they've just passed a new law. It limits the number of appeals, requires courts to speed up their cases. Slovakia has said that they will join us in efforts to persuade other countries, particularly Middle Eastern ones, to join the convention. Slovakia, they're going to be the president of the EU starting in July.
But they also had the Court of Human Rights, European Court of Human Rights, come down very hard on them in two of those cases. So there was, thankfully, additional pressure on Slovakia. Let me just ask you, because I know your time, and we do have two members that I'd like to get to. If Captain Paul Tolan's case is unresolved by next year, and there are 50 other cases, his is among the most egregious I have ever seen. Got very bad advice from the JAG as to how he should handle his case. He was obviously there, deployed to Yokohama as part of the defense of Japan, the joint defense that we are so happily engaged in, and I certainly support that. If his is unresolved, won't that trigger in and of itself, and then you add the other 49 cases, plus cases, for putting Japan on the non-compliant list, regardless of any progress they make post-Hague ratification? I mean, that's why when I went to Japan years ago, I said, if you don't have an MOU, if we're not working those cases aggressively, they will fall by the wayside, and the agony will be beyond words for those who feel left behind a second time. So if his case is not resolved, does that trigger it, in your opinion?
We are,
We will then be in the 13th year.
We are considering all options available to assist the parents, and we discuss within the department and with other parts of the U.S. government actions that might make a difference in a particular case or the behavior of a country toward the general group of cases. So there are no options that are off the table, and the report, the next second annual report under the new law, will reflect the conduct of all of these countries, Hague and non-Hague countries, in terms just as is required.
But again, I would hope if you could broadcast that signal to Japan, you could do it here today, hopefully you will, that Captain Tolan and others like him, I mean, this is a red line that ought to be laid down before Japan. You know, Japan will be hosting the G7 in the spring. Hopefully, these could be resolved by then. Otherwise, it ought to be a major issue discussed. I'm not sure if that's being contemplated or not, but maybe you could shed some light on that. Then I'll go to Mark Meadows.
I don't know about the agenda for the G7, but it is an issue that we raise consistently with Japan. They know this is one of the major bilateral issues that we want to see resolved. All of the cases, whether they began after Japan joined the convention or are among the dozens that were already underway before Japan joined the convention. The fact that Japan is a member of the Hague Convention reflects the power of persistent diplomacy by the United States and by other countries whose children had been abducted to Japan. And that does change the playing field for all of us, because
And cases are being resolved under the Hague?
we are pushing for
Japan?
that. There are 2 cases where judges have ordered the return of children to the United States.
Out of how many?
Of
2 cases out of...
cases that since they joined the Hague, where judges have ordered the return. That has not yet been enforced, however. So we're working to get those kids home.
Now, is that a law enforcement problem, or
It's, well,
or is it under appeal?
it's a complex, in both of the cases, they're both a little bit different, but the issue is making it clear to all of the authorities in Japan, and as you rightly point out, you know, the police or the judges or whoever, they're part of a government, and our engagement is with the government as well as with the particular part of that government that we think needs the special attention. So I am hopeful that we are going to see returns to the United States under the Hague from Japan. We're pushing for that in those 2 specific cases.
Mark Meadows?
Thank you, Mr. Chairman. Ambassador Bond, thank you for being here. Obviously, this is not the first hearing that we've had on this matter. Your colleague there behind you, she's been here before. And I believe that you have a real commitment to return these children to their parents. The frustration becomes and the reason for the Goldman Act originally was the type of soft diplomacy that you have described over really in much of your testimony, most of it has been soft diplomacy. And what you're referring to was really the whole reason why the Goldman Act was passed by Congress, was to give you additional tools beyond that soft diplomacy. And the frustration that has been evident in this hearing as well as other hearings is the fact that some of the tools that have been afforded the State Department are not being used. And so there's a law that's been passed. Now, I want to make sure I'm clear with you and with some of your other colleagues. I know your commitment is, as you put it, a #1 priority. The frustration on parents is each day, each birthday, each time that goes by, they don't see that commitment. And where it's a priority for you, it's the life for many of these parents. And there is the disconnect. So I guess my question, and I'm going to be very direct, has the State Department delayed or canceled one or more bilateral working relationships or official or state visits with any country based on a lack of cooperation? Have you done that? Can you point to any specific example where that's been done based on their inability to help us out? Has that ever been done?
Mr. Meadows, I have to admit that after 38 years at the State Department, I don't share your sense that soft diplomacy just doesn't get the job done.
I didn't say that. You've misquoted me. What I'm saying is you described soft diplomacy as what you are engaging in. I said the Goldman Act gives you additional tools, and I'm asking one of those tools, have you done that? Is there a case that you can point to?
So,
Listen, there's no one.
point to-
I made a living in soft diplomacy, so I understand the benefits of soft diplomacy, but I also understand when it doesn't work.
Diplomacy is I wouldn't even call it soft. It is a powerful tool, and I'm sure we agree on that. Your question about whether we have canceled any bilateral engagement.
Delayed or canceled, yeah.
Right.
I'm giving you the benefit of the doubt. Have you said that we're not going to have this bilateral working or official or state visit because you haven't complied? Have you done that?
No, as an example, that I'm not aware that we have done that.
I'm not aware of any either. So let me go on to the next one because I've got a limited time here. Have you withdrawn or limited or suspended any U.S. development aid because of noncompliance? I'm not aware of any, but we're having a hearing, so are you aware of any?
I am not.
Okay. Have we withdrawn, limited, or suspended any U.S. security assistance for any of these countries that are non-compliant?
Not to my knowledge.
Yeah. Have we withdrawn, limited, or suspended any foreign assistance to a central government of a country relating to other economic support?
I am not aware of any.
I'm not. All of those are tools that are available to you should quiet or soft diplomacy not work, and yet the parents are not seeing any of these being deployed. So let me, in light of your answers and knowing that you have a limited time, let me give you an analogy. I assume that you've occasionally exceeded the speed limit in your vehicle.
Yes.
Okay. Well,
On the record.
wait, yeah, on the record. Okay, all right. We won't say where. There is a place next to where I live where there is a city policeman that is there that literally will give you a ticket the minute you exceed the speed limit. And you know what happens? I don't speed through that town. And yet there's another place where we don't employ any of the tools that are available to our law enforcement officers, and I'm not quite as conscious about my speed. And so I offer that analogy to you because here is what many of these foreign governments are seeing, is that we passed a law, that you bring it up when you talk to their ambassador, and I believe that you do because honestly, I've checked with some of them and you do bring it up. But they see no consequences to their action or noncompliance. And that is the frustration you're hearing from this committee. That is the frustration you're hearing from parents. And hopefully that is the frustration that will be eliminated with the new report and as you employ some of the tools that have been granted to you by this Congress to make sure that we're effective. Does that make sense?
Yes, and Mr. Meadows, I think it's important to note that we are seeing action even in some of the countries that are the most difficult to work with at this time. For example, when I most recently met with the Brazilians for an annual bilateral discussion, and I was in Brasilia for that, and they talked about legislation that they're working on. So they're looking at ways to try to address the
But do you see the disconnect there? What you're seeing is maybe progress and action in terms of the potential for returning these kids. all the parents see is the kids don't come back. And so on your matrix of success, you're seeing progress. On theirs, they're seeing none. And I think that that is the difficulty here, and that's what we have to address. And hopefully this law will give you the tools to start to use, short of sanctions. You know, I'm not one, I don't like to employ sanctions, but there's a number of other tools that the Goldman Act allows the State Department to employ that they haven't done. And with that, I'll yield back, Mr. Chairman.
Thank you.
Thank you. Mr. Clausen.
Thank you for coming, Ambassador. And I think your job is a wonderful way to spend a life helping people and families like this. So congratulations and thank you for that. Since I've been here in Washington, D.C., we have talked about trade a lot. We just did the TPA agreement. We're now on the verge of the TPP agreement. And so let me give you just a little bit of context, Ambassador, why I bring that up. The U.S. is roughly a third of the GDP in the world, a little less than that. We are everyone's engine for economic growth and prosperity. No one does anything to lift up the poor in their country without trading with us, basically, for all intents and purposes. Our trade deficit every month is $40 billion. That's the deficit every month, $40 billion, roughly. If the price of oil goes up, that goes up a little bit. And so we are the economic engine for everyone, which creates leverage like, I don't know, every negotiated relationship in the world is based on leverage, as far as I can tell. And if that $40 billion a month doesn't create leverage with people, I don't know what does. We see Japanese-made cars. We see Korean-made cars. We all go to Walmart. That's a 90% Chinese-made goods, roughly. We know what the Indians sell here, the Brazilians. I mean, when I went down the list today as I was reviewing the data for this committee, I looked at all these people that we have enormous economic leverage. They cannot live without us. Now, if the administration is not serious enough to take their bacon away, then what are we all sitting around here talking about? We could solve corporate espionage tomorrow. We could solve kidnapped children tomorrow. In a month, one executive order. Give our kids back or you don't get to sell your cars over here. Give our kids back or you don't get to sell your software over here. And if we don't do that, how can we say we're serious? Because we're just saying the money, by the way, it costs all those imported vehicles just cost good paying jobs for hardworking Americans. They just go away anyway. So we let our jobs go away at $40 billion a month, and to add insult to injury, they don't have to bring our kids back. Now, I'm not getting this. I'm new to it. I hear what you all are saying about, cancel trips and cancel that. But as long as they're sending billions of dollars in here, making a living on our economy, and we're never using that leverage, I don't see this changing. I really don't. And so, anything I can do to help, but as a former business executive, we had plants all over the world. These are nice people in these countries. But until we hit them in the pocketbook, nothing's going to happen in my view. And so if you'll take that back. Now, if my world is too simplistic and you're seeing something different than I'm seeing, let me know. But the only thing I think these folks will understand is if we take a shot at it where it hurts, and that's in the trade agreements. And it can't go forever. I mean, we could do it tomorrow, in my view. This is all very, very solvable as soon as we take a shot at their imports that come into our country. Am I, sorry for the passion here, but am I too simplistic in my view here, Ambassador?
Oh, Mr. Clausen, when I was working on this same issue 10 years ago, the countries that I was most focused on were Switzerland and Germany, and Japan. It's been out there. Switzerland and Germany aren't on the list anymore because we have a very good working relationship. We're good Hague partners. If children are taken they come home. Very often, children don't get taken because the advice that the parent gets, who's kind of looking into, maybe checking with a lawyer, here's what I'm thinking of doing, they are told, don't even bother. Your children will be brought right back. Now, when we were originally talking with Switzerland and Germany 10 years ago, there were judges in those countries that were saying, why would I return a kid to the United States? It's better to grow up here in Germany. And this child has a German passport and a German mother. So I'm not interested in the Hague Convention. That isn't true anymore. So I can't agree with the idea that the only thing that anybody listens to is a threat of financial harm. I completely agree that the tools that are written into the new law are valuable ones, and that they are ones that have to be under consideration for use, and they are. But I do not agree that the best way to approach an issue is to say, well, all right, you've had 6 months, and we told you these sanctions were out there, so now we're going to come out with all guns blazing.
Remember, Ambassador, most of these countries don't allow our products into their countries. So you have people with enormous import tariffs. We don't have any import tariffs on what they ship in here. We can't ship product into their country that would help the American worker, and yet, our billions of American dollars go to their country every month. And we're going to talk for years about bringing back the kids. That may be success in y'all's view. That's too slow in my view, particularly when I got all the leverage. I got all the leverage because they're selling to me. We got this big trade deficit, which creates the leverage, and thank you for your hard work, and I yield back.
Thank you.
I want to thank Mr. Clausen, who is a very accomplished CEO, for that breath of fresh air. They do listen and stand up and take notice, and I believe are moved. You mentioned, Madam Ambassador, Germany. Germany, according to the figures put out by you guys, has a abduction case resolution rate of 27%, 4% better than India, which is on the non-compliant list. 27% doesn't sound all that good to me. So I wouldn't lift up Germany, with all due respect, when they have such a poor resolution rate. Let me also, in Switzerland, we didn't have any cases. The department didn't cover abductions to Switzerland because we didn't have any last year. But Switzerland is known internationally for not complying with the text of the Hague Convention and relitigating best interest determinations. So again, I'm not sure that's a stellar example to be pointing to either. I do have a few questions, and then we'll move on to panel 2. Has Japan's ratification of the Hague Convention helped resolve any of the 50 pre-Hague cases? Again, I do hope if you have an opportunity to listen or at least read his testimony, Captain Paul Toland will be next at the panel. But have any of them been resolved? You mentioned 2 that are post-Hague, and they're not even returned yet, which clearly begs the question as to delay is denial. But none of those, have any of them been resolved? And are we working on a MOU or bilateral agreement with Japan now for those pre-Hague conventions?
The pre-Hague families, of course, have only the option of requesting access under the Hague. And there are a number of left-behind parents who have filed requests for access. And that's, in individual cases, I actually am not in a position.
Again, underscoring why there needs to be an MOU. I mean, access, while that may be nice in a context, it is not what is being
It's not
requested.
what they want.
No.
Right. No, we are talking to Japan about how can we have a framework, a structure, an agreement for addressing the cases that don't fall under the Hague Convention.
When do you think that framework might be forthcoming?
I don't know.
Any sense? And again, delay is denial. Having, through contacts and long conversations, met with so many left-behind parents, frankly, starting with David Goldman, the tears are flow every day. Delay is denial. If you could get back to us with when that might occur,
We are
and with whom? Who are your interlocutors?
talking to the Japanese very, very consistently about resolution of the cases that predate the convention. So we absolutely are focused on trying to find resolution in every one of those cases. In some of them, it may be that access may lead to a resolution as the children are able to reconnect with parents that they have lost contact with through the years.
Let me just shift briefly to Brazil. And it was great to be with you at the press conference with Dr. Brand, Jared Gensler, David Goldman, in pressing for the return of Nico Brand. As you know, federal judge Ariel Duarte ruled that Nico Brand had been in Brazil 2 months, far less than the year prescribed by the Hague Convention, and was, quote, well settled and would not be returned to the U.S. despite admittedly illicit abduction that took place in Texas. And I've seen the court papers. His wife, that is to say Dr. Brand's wife, had agreed that this wouldn't happen, that they were coming back from the so-called vacation. Dr. Brand is 2 years into his abduction fight. Devin Davenport is 6 years in his case. He has won at every level, and yet he can't get his daughter home. Quiet diplomacy, it seems to me, has not worked. David Goldman, was well over 5.5 years in his quest, and through the grace of God and a lot of effort, thank God he was able to get his son back. But these others have not been 6 years. That now exceeds David's time. Why isn't there a sanction? I mean a sanction against Brazil. I don't understand it.
Well, we are working to get those kids home. We are working to make sure that the Brazilians understand that they have got to find a way to improve their judicial process. It's designed to permit a lot of appeals, but as a result, they are not living up to their commitment to turn these cases around and get the kids home. And so we agree. Brazil's Attorney General, as you know, is filing an appeal of that judge's decision in the Brand case because the government of Brazil agrees that judge was wrong.
I understand you will have to leave soon, and so I'll submit a number of questions, but just a couple of final ones just to conclude. On extradition and extradition requests, tell the other country we are very serious about resolving abduction. This is especially helpful in non-Hague countries where abduction is not taken seriously. The Goldman Act lists extradition as an action the State Department should be taking in concert with the Department of Justice. How many extradition requests are pending on abduction cases? Are there any pending in India, a non-Hague country where 75 open, long pending cases at the end of the year, about half are more than 5 years old? I mentioned Mindy Phillips earlier, who I have gotten to know very well, and her case is just filled to overflowing with fraud. The police in her township, it's not in my district, have done yeoman's work in documenting how she was defrauded, as well as adding additional pain to the abduction itself, because she was also ripped off, stolen from. What is being done vis-a-vis extradition?
Mr. Chairman, the issue of extradition of the U.S. government requesting the extradition of someone to the United States is a decision that's made by the Department of Justice, and so I really would have to refer you.
Oh, I understand that, but is it something that your office weighs in, or the Office of Children's Issues? I mean, they certainly would look to you for guidance. Mm-hmm. I mean, on Mindy Phillips, I think there ought to be an extradition done in that case. And certainly a thumbs up, an admonishment from your office would go a long way to sharpening their focus, because obviously they have a lot of cases and prosecutorial discretion that they have to deal with. Mm-hmm. terms of what cases to take.
Yeah, and it is absolutely one of the options that is out there for cases where we think and justice agrees it would make a difference.
But you know of no case as of now?
I don't.
Okay. Could you get back to us if there is such a case making its way through? Let me also ask you with regards to India, is a MOU or bilateral agreement being contemplated there? Because I know there's great push to have them sign the Hague, but again, that just grandfathers out all of those 100 children, 75 or so cases, including Bindi Phillips.
Right. Yeah, and as you say, we are hearing very positive comments from the Indians, with whom I also had meetings this month here in Washington, about joining the Hague. They recognize the fact that there are a lot of cases and that structure provides a way to address these and resolve them. So we would also then be talking to India about, all right, how are we going to resolve the cases that predate the convention?
Again, the argument was made as to why no MOU for Japan was that the atmosphere would be so improved under Hague that it would lead to possible resolution of those cases. Again, has any of that happened? Are they looking to resolve Captain Toland's case?
I know, as I mentioned, that some of the parents have submitted Hague access requests, and to the extent that they are able to resume regular contact with their children, that may well lead to actions that actually bring the children home, especially as the children are older and in a position to express their own interests in where they want to live or where they want to travel.
Let me just ask you finally, and this is regarding India and maybe other countries as well, but your reports to Congress this year and letters to left-behind parents, and I have one here, which we could share with you, showed some confusion regarding the application trigger for counting a case against a non-Hague country such as India. When desperate left-behind parents contact you, they are told there has to be an additional application procedure for their case to count as, quote, unresolved, but that the content and the process for the application is kept secret. One inquiring parent was told in response to her direct questions regarding an application has not been submitted, that's from the letter, that the State Department will do so when appropriate. For non-Hague countries, the Goldman Act starts the clock the moment the State Department formally raises the case by name with the country. What additional requirements have you added, if any, for an application? How can you fill them immediately in India? And we'll share with you this letter if you'd like to take a look.
I'm not aware of
the family came away with confused.
Yeah, I am not aware of any additional requirements that are asked for parents whose children have been abducted to India. And so I don't know whether there was a misunderstanding in what you're describing or a failure on our part to communicate clearly, but there aren't any, as far as I'm aware, additional requirements that are imposed on people on left-behind parents whose children are in India.
Right. I know you've indicated you need to leave. Is there time for Sheila Jackson-Lee to ask you a question?
Of course.
Oh, thank you. I yield to the gentlelady from Texas.
Let me thank the chairman for his kindness and the ranking member of this committee in this important hearing, and thank Secretary Vaughn for your presence here today. Dashed from the floor, so thank you for your patience. But I want to just hold up a face of mothers that have encountered challenges and difficulties even as this law has been passed. And I would like to be, I think all of us would like to be a help to the administration, to administrations plural, and to these families. So I first would like to get from you the sense of the importance of the law being enforced through judicial and law enforcement education. It seems that there is a difficulty. One case comes to mind where the court said, I don't have jurisdiction, I'm going to give it to Monaco. When the children are U.S. born, the mother is U.S. born, and a court is abdicating their responsibility. What do you think we can do with the education about the enforcement of this law?
Well, one very valuable, important tool that we have in terms of our education efforts is our network of Hague judges, federal and state judges who are experts on The Hague and are prepared and very actively go out and talk to their counterparts in other countries in order to address very directly the questions that they might have about how this process works and to reassure them about how the process works in the United States. So that's one of the education measures that we have. We also have brought scores of foreign judges and prosecutors to the United States to have the opportunity to meet their counterparts and to understand how the process works here and to exchange different cases they've worked on and just talk, robe to robe, if you will, about how the process works for them, how they understand it, and how the American judges handle the same cases. So I think that's very much at the heart of the work that we're doing, working also with the Hague Permanent Bureau, which has experts stationed in different regions of the world who also work to support different governments to make sure that they understand what they're supposed to be doing and that they get it right. In Brazil next week, there is going to be a judicial training program that is being organized with our support by the Hague Permanent Bureau.
I'm on the Judiciary Committee, and I think the education is a problem, and I think also it might be helpful if the Justice Department joined in with the State Department as relates to the judicial enforcement. Again, that's part of what you're saying, the understanding. I guess my concern is that the Goldman Act has not been as strongly enforced as the intention was behind the passage. How do you think a collaborating with the Justice Department on the enforcement end would be helpful?
Well, Congresswoman, we actually do collaborate very closely with the Department of Justice. We work very closely with the FBI on, especially in blocking abductions of children from the United States, but also in addressing different cases. And Justice is very much involved in the work that we're doing, the interagency work on preventing the abductions and also on working to effect returns. So I absolutely think that greater coordination with Justice is a good idea. We have twice a year, we have a specific interagency meeting, which includes the Department of Defense, it includes Justice, DHS, and others, state, of course, because we lead it, to talk about what more we can be doing as a government to address this issue and to prevent the abductions, but also to address the situations of the families that are already caught up in this.
And you can imagine that's very painful, and I think we can only judge ourselves by the numbers of children that get reunited legitimately or legally with those parents who found themselves in the international quagmire, and they're just, whether they have lawyers here, they're just grounded by this huge umbrella of international affairs that can really be insurmountable for just an individual who lives in Iowa or an individual who lives in New Jersey or Houston or in the state of Texas, just insurmountable. So let me ask this. In those meetings, the FBI independently is there with the DOJ? Is that the enforcement arm, the FBI?
Yeah, FBI is also there.
Then can you, I think the question would be, and we have the greatest respect for the mountain of responsibilities our law enforcement have, and we thank them all for their service, but we wonder whether or not there's an educational issue there, and what do you, the State Department, who is the overseer, if you will, of the success stories? How much enforcement is the FBI engaged in? Are these cases high priority cases? Can we determine how many cases in the law enforcement term have been made by the FBI using the law, and do we need now to assess that part of it, the enforcement that then brings these cases before the court?
Well, we work, as an example, very closely with the FBI and local law enforcement when we are notified by a parent that that person believes that there may be an abduction in progress. We have 24/7 operators who are, they're not operators, they're officers who are trained in abductions who are available to take calls if people call in and say, you know, I just came home, my wife's not here, she left a note, I think she's planning to fly out with the kids. Our officers are able to give very immediate, direct instructions to the parents. If they don't have a court order, they need one, and they're told exactly what to do. And we hook up with CBP, with the FBI, with local law enforcement in order to act to interdict that abduction. So that's an example of a process that works very well. You spoke, and it's absolutely true, to the challenge to the average citizen of understanding, you know, what do I do now if my child has been abducted to a foreign country that I may not even know that country very well. And that's why we have a team of officers working in our Office of Children's Issues, the prevention team, but also the abductions team that they're part of, to provide information to the families that are caught up in this nightmare, and to make sure that we're well linked up with the central authority in the other country if it's a Hague partner, and to follow up on the case and provide the advice and the guidance that we can for non-convention cases to help people identify a lawyer in the other country and understand what their options are.
Let me add, and I appreciate that, but let me add, and hopefully I'm being helpful to this committee, of requesting that we get a list of the cases, active cases that the DOJ, and working with its international law enforcement, are acting upon now. It's interesting, as the chairman has taken the lead, ranking member, I'm on Judiciary and Homeland Security, two of the departments that you've mentioned, so I think there's an opportunity for a partnership here, but to get the list of cases, active cases, and then the second would be the list of cases that have resulted in the extradition or the return of these children, because in most instances it's children. I think the intent of the Goldman law was to stop the bleeding. We were just amazed at how many cases, how many families had experienced this, and with their own domestic-based lawyers, some may have international experience, they just were just going up against really the firewall of sovereignty. And we were trying to find a way to pierce that and give some hope to individuals. Stories that we've had before this committee, that I have the privilege of sitting in on this committee, were ones where the family wound up in a domestic court in California, for example, and then just completely obliterated in terms of that case, giving up jurisdiction. I don't know how, I'm just baffled as I conclude how a local court ignores the citizenship of the children, which are U.S. children, and they send them overseas. I'm just completely baffled, with no showing of a parent that is not able to provide for them here in the United States. So then when they are taken, we'd like at least the Goldman law to step in and give some equality, some equal playing field. So it'd be very helpful. I think what we need to do is to really hear from all of the agencies. The State Department is certainly working, but you are collaborating with the Department of Justice, Homeland Security, to a certain extent, some of the local law enforcement, to understand that the law is in place and the law can be useful to save some of these individuals, which I'd like to see. So if we could get both of those numbers, it may be helpful to this committee and the chairman, and then we might be able to, again, look at our other agencies and how they can be helpful in collaborating to bring some of these children home. And I don't know, as I close, Secretary Bond, do you have any recent examples of success, whether you call it case A or B, do you have an example of the reuniting of children that have been abducted, brought home to the United States?
Oh, absolutely. There, in terms of what you were speaking to just a moment ago about the interagency work, including the FBI, a lot of that is focused on prevention, discussions of what more we might be able to do to inform parents who may be at risk for this sort of thing, to make sure they know what steps they need to take to protect their children, and also to ensure that there's a coordinated response if we get an indication that there is an abduction underway. That's a lot of that focus from the FBI and law enforcement and other parts of the interagency working together. But there have been several hundred returns. There are also, of course, we don't know how many cases where children were protected from abduction because of advice that their parents got by calling into our team or by reading the information that's on our website, so that they would be aware of the fact, for example, that you can register with Passport Services the fact that even though we require for all minors, both parents have to agree to the issuance of a passport, you can take the additional step of saying, I want you to contact me personally if any application for my child is filed, because I want to be sure that my spouse doesn't, pretend to have a notarized document from me that's false. So we have that program, and we have other programs that are available for people to ensure that their children are protected or flagged, so that they won't be the victims of an abduction. But of course, that doesn't help in every case. We have plenty of cases where the child traveled with both parents' knowledge and agreement because one parent didn't know what the other parent was planning. So,
Yeah, and that's where the abduction comes in, and that's the problems that we'd like to solve. So again, let me add a third request. If you have to protect the privacy, but if a report we could find a list that is either listed by number or something that says, we return this person from Kosovo and to the United States. But I'd like to see the list to see how we're doing. Is it over a period of years, or is it in the last year, or?
we submit an annual report on
Right,
the subject,
under the
and
law.
it does include the statistics on the returns by country.
And the most recent annual report was when?
Was
it
issued in April 2015.
in April. If you're about to get your other annual, but I'd just like to ask for that report. I know it comes to Congress, but I'd like to
We'll make sure
ask
you
for it.
get
And if there's an updating between now and then, I'd appreciate that as well. Mr. Chairman, could pursue a whole line of questioning, but I'd like to yield back. Thank you.
Thank you so much.
Thank you very much, Secretary.
Can I just ask you, Sheila Jackson-Lee's question prompted a question for me, and that would be, as you know, Title III outlines or makes clear that there needs to be an interagency working group headed up by the Secretary of State, and it would include Homeland Security, Department of Justice, and would also work with Department of Defense. Has that interagency group met, and what has been the outcome? How often do they meet?
So far, I believe they've met twice. And in addition to the agencies that you have mentioned, they also include now, at the most recent session, the Attorney General of Utah attended, because they're also reaching out to the state-level officials who would be in a position to contribute to a discussion of how can we get this done better, how can we protect the kids. So those will be regularly held.
This is the final question, and we'll submit the rest for the record. But in June, at a June hearing, sitting right where you're sitting, was a woman by Ednina Barbourou from Tunisia. She has been trying to get her son, Eslam Chebi, back home to the United States. She testified, her testimony was very, very riveted. She has won 4 court orders, and yet she still has not gotten her son back. Secretary Kerry recently praised Tunisia for being an example of democracy. And again, despite these court orders, she does not have her son back. What is the department doing to get her son back?
She's present here today, as a matter of fact, and we were chatting a few minutes ago. I'm, of course, very familiar with her situation. To be honest, I think due to the Privacy Act, I actually can't go into the details right now of what the current status of her case is, but we are very engaged on it and remain hopeful that we'll be able to get him home. As you say, the courts have ordered his return several times.
Thank you. And I will submit some additional questions, and members might do it likewise. Thank you for your testimony.
Thank you.
I'd like to now invite our panel two, beginning first with Mr. David Goldman, a father of a child abducted to Brazil. Mr. Goldman is father of Sean Goldman, who is here in the audience, was born in Red Bank. Sean was abducted to Brazil in 2004. Mr. Goldman spent the next 5.5 arduous years, enormous amounts of time and financial resources, and had a great number of people supporting him in the New Jersey community and really around the country to secure the return of his son. In December 2009, Christmas Eve to be exact, he actually got his son back and flew back to the United States, and what a great reunion that was for not just David, but for his entire family. I would thank him for the work that he has done, not just for himself, but the Bring Sean Home Foundation and the other work he has done. He has been a shining example of what can be when the levers of government, the private sector, the media, all work in concert to bring about justice and, in this case, a much-needed family reunification. We'll then hear from U.S. Navy Captain Paul Toland, who has been fighting for access to and return of his daughter Erica since 2003. Captain Toland, she was abducted, I should say, as an infant from a Navy family housing in Japan. Captain Toland has been the sole surviving parent since 2007, when Erica's mother died, but it still has been prevented from reunification with his daughter, who is living with her grandmother. Captain Toland recently launched a new legal effort in Japan's courts, calling on the courts to recognize the fundamental human rights of a biological parent to have access to his or her child. He is the co-founder and national director of Back Home, a nonprofit organization dedicated to the immediate return of internationally abducted children who have been wrongfully detained, especially in Japan. I'd like to begin with Mr. Goldman and then go to Captain Toland.
Thank you, Mr. Chairman, and Mr. Meadows, and Ms. Jackson. It's wonderful that you're here to support this. I know Mr. Meadows has been here on a few of these hearings, and we appreciate that. I'd like to just start before I go into my actual testimony. And all these hearings that I attend and some participate in, I do keep hearing about the quiet diplomacy. And I always wonder, like, the questions that you ask, instead of deflecting them, what is the real reason that they won't use the tools in the toolbox? What is it? Just come clean. We don't believe in it. It's against what we stand for. I always thought it would just be against, they're more concerned about their bilateral relations than the 100 children in this country, the 200 children in this country. They're more worried about trade. They're more worried about arms. They're more worried about drug smuggling, border control in certain countries. But why can't they just basically come clean and say what's the reason they won't use the tools in the toolbox that they need, that they wanted? I just listen, and we talk about Brazil. They've acceded to the Hague Convention in 2004, and they're always on noncompliance. They just said 9 times consecutively noncompliant. When is it time to use the tools? Does it take 9 years? Some child who's kidnapped at 9 is now 18-year-old. They're a grown-up. They're not a child anymore. That goes in complete contra Hague Convention, what it stands for. 9 times, and they're non-compliant, and that does show that quiet diplomacy in that case doesn't work. And as you said, a 27% return rate from Germany, to me, doesn't seem very successful. But I diverged because those are just points that I just hear every time. And so I'll give you a brief history of my case. For 5.5 years, I was a left-behind parent. I did live in a world of despondency and desperation with a searing pain through my entire being. Everywhere I turned, I saw an image of my abducted child. Sleep was hard to come by. It was never restful. If I smiled, I did feel guilt. When I saw children, whether it was in the store, a park, on television, or on my charter boat, where clients often take their families for a day on the water, it was more than painful. For the longest time, it was too painful to be around my own nieces and nephews. I was wondering, I wanted to be, and where was my son? Where was my child? He had been abducted. He had been illegally held. He was being psychologically, emotionally, and mentally abused. I needed to help him, but I was helpless. I needed to save him. He needed me, his father. It was our legal, our moral, our God-given right to be together as parent and child. I did everything humanly possible, leaving no stone unturned, but for many years the result remained the same. My son, Sean, was not home. There were court orders in place, many court orders from the U.S. demanding the immediate return of my child. The courts, as you pointed out, Mr. Chairman, acknowledged that my son had been held in violation of U.S. and international law. However, he remained in the possession of his abductors. Why were so many laws being ignored? Why were the abductors, and in my case, the government of Brazil, allowed to flagrantly violate international law without consequence? Why were my child and over 50 other American children still in Brazil, another plus in Mexico, and thousands of other American children also held illegally in other countries in clear violation of the Hague Convention on the civil aspects of international child abduction? It would take 4.5 years, numerous court hearings, extraordinary work from my attorneys in Brazil and the U.S., and a tremendous amount of political pressure applied publicly and internationally, and House and Senate and state resolutions for me to finally be able to visit my abducted son for a few short periods of time. It took Congressman Smith traveling to Brazil with me. It took Senator Lautenberg holding up a trade bill that would have given Brazil nearly $3 billion of trade preferences for my son to come home. So as I prepared today's hearing, I began to review my own testimony from previous hearings, as well as testimony of others who had given powerful and moving accounts of their own experiences with this issue. In past, what was obvious was that our government lacked the tools they so desperately needed to bring abducted American children home. That's not the issue any longer. It has been over a year now since President Obama signed the Goldman Act into law. And thank you, Mr. Chairman, for authoring that legislation. It is much needed, and I hope we can use it. I hope our government use it. I beg, I plead on behalf of all these other left behind parents and families and grandmas and cousins and nieces and nephews in the community that they were ripped away from, that we use the tools to get these children home. It provides our government with a number of options to persuade countries to return abducted American children. One of our first duties of government is to protect its citizens, and the Goldman Act does just that. We no longer need one senator. Important, we no longer need one senator to hold a trade bill in which 131 countries would see tariffs on their imports to the U.S. rise sharply and billions of dollars of their trade disrupted. The Goldman Act is designed to work country to country, on a country-to-country basis, and may impose punitive measures against individual nations harboring abducted American children. And I go to the press release. There can be no safe havens for abductors. That was released yesterday by Secretary Kerry. Point in case. Let's take action. We need not, our government need not be so concerned about upsetting a country that harbors child abductions of American citizen children. We must demand the return. We are not asking for any favors. We're expecting the rule of law to be followed. And if it isn't, then let them see there are tangible consequences. And when we do, and hopefully we will use some of these powerful tools, stronger tools, they're not permanent. They send the children home, and whatever penalty, whatever punitive measures they face may be lifted. It doesn't mean it's forever, but let's make a statement. And if they get angry at us, how can we be concerned about a country being angry at us for demanding our American children home? These are our citizens. It's our duty to protect them. We can't be concerned if they're going to get angry at us for demanding the return as they would their own. It's intended to work side by side with the Hague Convention on the civil aspects of international child abduction, ensuring countries honor their treaty obligations. In this way, the Goldman Act almost acts like a bodyguard to the treaty, protecting it and ensuring that it is followed as it was intended. It took several years and several markups before becoming law, and we now have the ability to help bring home this country's abducted children with both Hague signatory countries as well as non-Hague countries. I would just quickly like to address the criminal approach. We talked about Department of Justice. And in my case, as well as most cases, the first instincts are to pursue criminal remedies, go to the police, hunt down the abductors, and hope for return of the child through law enforcement. I understand and sympathize with that approach, and that was, in fact, my first instinct. But I do think that approach adds another layer of complexities to the process. What the Hague Treaty does in simple terms is put a signatory country it puts all signatory countries in agreement on how the issue of international child abduction should be resolved without complicating it on the basis of cultural and domestic laws. Essentially, there are two extremely important issues that arise from criminal proceedings and demand from extraditions of child abductors. Domestic courts will often refuse the return of an abducted child, knowing that the taking parent will face criminal prosecution by coming back to the country where the child was abducted from. And many countries, it's in their constitution, they just simply will not extradite one of their own citizens. And even if they do extradite one of their own citizens, so you got the abductor back, but the child is still over there. It just adds a whole other layer of complexities, and that's why the basis of the Hague Convention is on the civil aspects, and that's why the tools of the Goldman Act are civil actions. And as we also talked about, with regard to the Hague Convention itself, there are two areas which are most often abused by the foreign judges when deciding these cases. One is in Article 11 about the judicial administrative authorities shall expeditiously in proceedings shall act expeditiously to return the children. And if they don't reach that decision within 6 weeks, the date of commencement of the proceedings, the applicant or the central authority of the requested state on its own initiative, or if asked by the central authority of the requested state, shall have the right to request a statement for the reasons of the delay. So clearly, the spirit of the convention is to have these cases handled swiftly so that there is little disruption as possible in the life of a child. We all know that is not what happens most of the time when Americans are abducted because of the endless legal delays resulting from motions filed by the abducting parents. The convention's intent is thwarted and the spirit of the convention is lost. And as an example, they use Article 13b about you don't have to return a child if the court where the child was abducted says there's going to be grave risk or harm to return the child. So what they do is they interpret these legal delays and proceedings as the grounds for denying the return of a child based on the assumption that the passage of time somehow eliminates the urgency of returning that child to their home country of habitual residence. Because of their own slow judicial process, they say it's now going to disrupt the abducted child to return them, thus rewarding the kidnapper. As Congressman Smith mentioned, the case in Brazil, which is going on right now, they actually denied Chris Brand's, Dr. Brand, who, I take a side note, he is a internist. He works at Baylor University in Texas. He dedicated his life to helping others, yet he can't help his own child. He can't nurture and help and be with his own child. Someone whose calling in life is to help, heal. He can't even participate in his own child's life, and the pain he's experiencing, as well as all the other parents, is just tremendous and devastating, and there really are no true words to imagine the level of despair that these parents suffer every day. But in this case, the judge cited, in Chris's case, the denial of my son because of the passage of time and the well-settled issue. They denied the return of his son, citing my case. I was floored when I realized that, when I read that. This judge that decided his case must have never read the news, seen the television, or looked at a legal precedence, because my son is home. And he's been home for nearly 6 years. So for her to cite that case is just showing that they're looking at any reason to not return children. Another example in Brazil, and this is about the enforcement issue. So now we have one judge just denying the return in a blatantly disregard for the law. Another case is Nadia Davenport. It's been more than 7 years since Devin Davenport's baby daughter was abducted from North Carolina to Brazil, and he has fought admirably to bring his daughter home, and he's even testified before the same committee last year, making an impassioned plea for help. The Brazilian court has ordered his daughter, Nadia, home, and all legitimate appeals have been exhausted, yet nearly 2 years have passed since that decision without enforcement of the return. And Nadia remains in Brazil illegally, and Devin Davenport is no closer to being with his child. So we have a country non-compliant for 9 times. When they do get a judicial order, it doesn't get carried out, if they do get a judicial order. There's no country that screams that's a member of the Hague for this long to try your quiet diplomacy, to use the tools. And these parents, like so many others, suffer so much. It is beyond words to describe, and I know because I was one of them. I did feel like a dead man walking, lifeless, struggling day to day to get through the most meaningful and meaningless tasks. I am now so fortunate to be on the other side, having been reunited with my son. And to my knowledge, to answer a couple of your questions, Sean, my son Sean Goldman, is the only American child ever to be returned from Brazil to America under a court order under the provisions of the Hague Convention. So you asked the question, that's the answer. My son is the only child ever to be returned from Brazil to America under provisions of a court order under the Hague Convention. And they've been acceded to the treaty since 2004. We are lucky. We can't recover the years we have lost, but we can enjoy our time now. We can live as parent, as child. I can watch him grow, evolve, and become a young adult. We can interact with each other, participating, educating, encouraging, and disciplining, as a parent should be able to do with their own child. And so many other left-behind parents were given hope and painfully celebrated my son's return without their own children at their side. And please don't allow their hope to be a cruel and anguishing false hope that their children may one day come home. Accompanying me to this hearing today are my son and stepson, Sean, and his stepbrother, Jesse. They are brothers and good buddies, and Sean can grow up as a normal boy with family and friends like it was intended. I was able to assume my role as his father and he as my son. It is our legal and God-given right to be father and son. And next to me is Captain Paul Tolan. The empty chair behind him awaits for his abducted daughter, Erica. It is this government's duty to protect its citizens, to protect the rights of Erica, and allow her to come home to America and grow up in the care of her father, her only living parent. The tools are in place. Please use them. Help Paul reunite with Erica. Please help these suffering mothers and fathers reunite with their abducted American children. Our country is about keeping families together, and they desperately need your help. Paul needs your help. We have the tools. Let's use them.
Mr. Goldman, thank you so very much for that very passionate, well-informed, articulate, not only telling your own story, but your concern for all of the other left behind parents. And with that, I'd like to yield to Captain Paul Toland.
Thank you. And thank you, David, for that touching speech. Congressman Smith, Congressman Meadows, Congresswoman Jackson Lee, and other members of this committee, thank you for allowing me the opportunity to speak today about the scourge of international parental child abduction, specifically with regard to the country of Japan. I'm here today to explain to you why punitive measures, up to and including sanctions, may soon be the only viable option that will bring about the change necessary within Japan to comply with the Hague Convention and the Goldman Act. My name is Paul Toland. I'm a captain in the United States Navy with over 26 years of active military service. I am the co-founder and director of Bring Abducted Children Home. My daughter Erica was abducted off a U.S. Navy housing in Japan over 12 years ago. In 2007, my wife Etsuko committed suicide, and since that time, Erica has been wrongfully retained in Japan by her grandmother, Akiko Futagi. I was recently in Japan, where I filed through their family court system for physical custody of Erica. Japan signed the Hague Convention in 2014, but abduction cases like mine that transpired before Japan's ratification of the Hague are not eligible for returns under the Hague. So I am utilizing the Japanese system to see if they will, in fact, respect the rights of a parent over a non-parent and provide custody to me, Erica's only living parent. Yes, Akiko Futagi is a grandparent to Erica Toland, but that also means she is not a parent. Under law in most countries, she would have no right to keep my child away from me, and yet to this day, she has been allowed to keep Erica away from me without allowing so much as a phone call in 8 painful years. In most countries with modern family law systems, this abduction and denial of access to a parent would be perceived no differently than if a stranger abducted a child, and it would be a felony crime. But in Japan, abduction by a non-parent relative is not only accepted, it is condoned. I am the only parent in the world to Erica, yet every day I have no idea if she is sick or injured. I have no idea if she is safe or in danger. I have not even been offered a single photo of my beloved daughter in the 8 years since the grandmother has held her, let alone a visit or a walk in the park together, or the opportunity to say happy birthday, even once. Historically, Japan has stood alone in the modern world as a notorious haven for child abduction, and is still considered a black hole from abduction from which no child ever returns. The Japanese government has never enforced the return of a single abducted child, including over 400 American children abducted to Japan since 1994. But recently, there has been some hope for change in Japan. Japan has signed the Hague Convention, and many Japanese politicians are speaking openly about changing Japan's views on parental abduction and shared custody between parents after divorce. Those inside and outside Japan who want Japan to change and become a modern country in regard to parental rights see my case as an opportunity for Japan to prove to the rest of the world that it is changing and that Japan is moving forward toward joining the rest of the developed nations of the world. For Japan to prove this to the rest of the world, we fully expect that the Japanese court will both order and enforce the return of Erica Toland to me, her father and only living parent. The judge's ruling in this case will be a reflection of the entire Japanese government and the entire nation of Japan. There could be no clearer case than this case for Japan to demonstrate that it has at least a very basic and rudimentary understanding of its responsibilities toward parents and children. How can we expect Japan to ever resolve more complicated divorce and child custody issues if it cannot even resolve this very straightforward case where one parent is deceased and a non-parent is withholding the child from a loving parent who wants to care for her? The U.S. Supreme Court has found that, and I quote, "The interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests." The U.S. Supreme Court has further ruled that it is cardinal that the custody, care, and nurture of the child reside first in the parents. And that same court has held that the relationship between parent and child is constitutionally protected. As in U.S. courts, the rest of the modern developed world would never tolerate a custody battle between a parent and a non-parent. In civilized countries, the automatically presumption of the court would be that the best interest of a child is to be raised by her parents, not some other more distant relative or stranger. A parent does not have the burden of proving that he or she can raise a child better than a non-parent. If Japan rules, as it should, in favor of my daughter's right to know and love her father, then it would truly be a threshold step for Japan, and Japan would be closer to joining the rest of the international community as a nation that respects the basic fundamental bond between parent and child. However, after attending family court in Japan last month, I came to a single conclusion regarding the Japanese family law system. Nothing has changed. That's right, the court system is no different than it was 10 years ago. The courts still have no mechanism of enforcement. The courts still drag cases out over many months to run out the clock, and judges simply find a way to maintain the status quo. In my clear-cut and unambiguous case, I have endured 3 court dates over the course of 8 months, with another court date set for December and no end in sight. Signing The Hague was simply a smokescreen devised by Japan to relieve international pressure. The Japanese Ministry of Foreign Affairs knows this. They know that Japan's family court system is a completely broken mess. And that is why they have done everything in their power to keep Hague actions out of their court system and instead attempt to resolve cases through mediation and provide access via monitored video conferencing between victimized parents and children. These efforts have all been dismal failures. Why would an abductor want to mediate, knowing that he or she can withhold a child without consequence? All they need to say is no, and there is nothing that the Japanese government will do about it. Other recent signatories of The Hague, such as Korea, have made necessary reforms to their family law system, but Japan simply refuses to do so. And because of this, they can never be compliant with The Hague. It is literally impossible. So what are we to do about it? How will Japan make the changes it needs to join the rest of the global community? I, and everyone who has been associated with this issue for years, have come to a single conclusion: foreign pressure. Yes, that is the only solution that can bring about change within Japan. Real changes to human rights issues in Japan are rarely, if ever, accomplished internally. Instead, it is almost exclusively foreign pressure that elicits change in Japan. Take child pornography as an example. For years and years, Japan openly allowed possession of child pornography and did nothing about it. It was only the intense and continued foreign pressure that compelled Japan to make the changes necessary to join the rest of the civilized world in this area. Likewise, it will only be constant and intense foreign pressure that will bring about the required changes in family law that will allow Japan to comply with the Goldman Act and the Hague Convention. The State Department has been completely remiss in applying foreign pressure to Japan or demanding the return of any of the 400 children kidnapped to Japan since 1994. They have instead actively tried to cover up for Japan's noncompliance with no regard whatsoever to the suffering of countless American parents and children. If Japan rules against me and demonstrates that it cannot and will not protect the fundamental bond between parent and child and the inherent rights of parents, and if Japan continues to deny access to parents under the Hague and fails to return abducted children under the Hague, I ask for punitive measures, up to and including sanctions under the Goldman Act. Why do you think Brazil returned Sean Goldman? It was because of the threat of sanctions, as David just alluded to, holding up that trade bill. That's what really hit home. And then after Sean was returned, thank God he was returned, then that pressure was relieved. They were no longer holding up the trade bill, and no more children were returned. That speaks for itself. Sanctions represent a real expenditure of political capital on behalf of the United States. I once told a high-ranking State Department official that our children could be returned in 1 year if the United States government was willing to expend real political capital on behalf of our children. If a governor or some famous celebrity's child were abducted overseas, you can bet our government would expend every resource possible to ensure the return of these children, their children. But the sad reality is that our children are simply not important enough for the American government to expend the political capital necessary to return them. Additionally, if Japan cannot protect the fundamental bond between parent and child and the inherent rights of parents, then no American families are safe in Japan, including military families. If our military families, members and their families stationed in Japan can lose their children so easily in violation of our constitutional protections, then the military will need to rethink its policy of allowing family members to accompany their military sponsor to Japan. Ever since Erica was stolen from me over 12 years ago, my only desire in the world and everything I have worked for has been done with one goal in mind: to be reunited with Erica so she can know and love her only father, and so I can know and love my only child. That goal has never changed, and it never will. I have heard some people from Japan say, "Why would you want to take Erica away from her home in Japan?" Well, to that I say, Japan is not necessarily her rightful home. It is not even necessarily the United States. A child's home is with her parents, no matter where that may be. And that means that no matter where I may reside, Erica's home is and always will be with me. True, it's a fact that she's 13 years old now, and she may not want to come to America. And if that's the case, she and I will work that out together. I will ensure that I have the best team of reunification experts and medical professionals to help us through these times. Japan expeditiously ruling in my favor will sanctify the sacred bond between parent and child. Japan expeditiously ruling in my favor will be a recognition that these difficult issues regarding Erica's futures are issues that she and I must face together. And it will also recognize that neither the state of Japan nor a more distant non-parent relative will come between the sacred bond of parent and child. However, if Japan rules against me and violates this fundamental bond between parent and child, and continue their pattern of denying access to parents of abducted children, and fail to expeditiously return abducted children under the Hague Convention, I once again ask that punitive actions be taken by the U.S. government to include sanctions under the Goldman Act. Only foreign pressure will resolve this situation, and that foreign pressure starts right here in this room. Thank you.
Captain Toland, thank you so very, very much. Again, an extraordinarily eloquent statement, an expression of a father's love for his daughter, Erica. And I can assure you that this subcommittee and Mark Meadows and other members of the committee are steadfast. We will be unceasing in our efforts to try to get your child home, the other children who have been abducted, and to use the Goldman Act as it was intended, to use it. Words are cheap in this town, and I've been here 35 years now, and I can tell you, far too often people make these statements. Secretary Kerry made a very fine statement yesterday that all the tools will be used. Well, they have to be. And Ambassador Bond did not make clear whether or not even now, with the gap that they had in the original report, that Japan, with its 50-plus cases, and even those post-Hague not being resolved either, would be designated as a country with a pattern of noncompliance, and that is very deeply disappointing. And I think your point about the Hague being a smokescreen, never more truer words were ever spoken. Now, it may have a positive ameliorative effect going forward, but as we argued right from the get-go, when this administration, they're doing the same, it's like deja vu all over again, to quote Yogi Berra. It says they're just committing the same act vis-a-vis India with all the 75 cases that are unresolved. So I can assure you we're going to do everything we can to keep the pressure on. I will initiate a letter. Hopefully we'll get members of the House and Senate to sign it to the President that the G7 meeting that will be held, the 42nd G7 Summit on May 26th to 27th in Shima, Japan, with Japan hosting, of course, that your case and the cases of other left-behind parents and other countries do have similar situations, so my hope is that they will, too, rally. I remember meeting with ambassadors from other nations, mostly European nations, that had a very similar track record of not having their left-behind children brought back to their families as well and their parents. We do have 30 minutes or so of votes. If there's anything you would like to add, both of your statements were extraordinarily eloquent. Ambassador Bond's statements today, did it give you any hope? Frankly, I was concerned by a lack of commitment to using the tools, other than saying we'll use all tools, everything's on the table. But until you start sanctioning and having, as one of our colleagues said earlier, until you really start saying, we're not kidding, they will think these are mere words and admonishments rather than actions that have penalties and consequences. So if you'd like to add anything, please do at this point, and then we will conclude the hearing.
Congressman Smith, I'd just like to add one thing on behalf of a number of other parents that I'm associated with. We're currently, me and a number of other parents are seeing our kids that were abducted at a young age moving into their teenage years now. And we're hearing the same thing over and over from the abductors. The child does not want to see their parent. And this is from the abductors saying this, not necessarily the children. This is happening, I'll say, I'm hearing this from regarding my daughter Erica, as well as Randy Collins hearing it about his son Keizake, Chris Savoy hearing it about his children, Isaac and Rebecca. We don't know if these children are really saying this, or if the kidnappers are simply saying this as a last-ditch effort, but what we do know is that these children were kidnapped at a very young age and brainwashed for many years. Unfortunately, these children will never heal from the psychological damage that their kidnapping parent inflicted upon them. But our hope is that in a few more years, these victimized children will realize that most of their life was a lie, and we pray that they will come to know and love us, the parent that they were taken from. Thank you.
I'm still wondering, where is that disconnect? Why doesn't the State Department come out and say why they don't want to use these tools? I have yet to hear a legitimate reason, just sort of deflections. Secretary Bond, she was an advocate in my son's return. She spoke adamantly on national television. She's got the tools. She knows, they all know what it takes. They do have their hearts in the right places. They do work long, hard hours. But they have this right at their fingertips, which can make a difference. And if used against the worst offenders, it'll send a message to the other countries. And they are not permanent tools. Once they are invoked, they can be, you send the kids home, that penalty is removed. But knowing that it's there and knowing we will use it will make all the difference in the world. And I still am wondering, I don't hear an answer why, after 9 years, and only one child ever to be returned under provisions of the Hague Convention by way of court order, they don't want to open up every tool, and use every tool in their toolbox to get the kids out of Brazil specifically, and also India, Japan, these countries that aren't Hague countries can use the same tools. And that's one of the questions that I still have never heard an answer from. And thank you, Mr. Chairman. I know you
We're
have
out of time. Without objection, a Washington Post editorial from August 12th will be made a part of the record, and it cites Jeffrey Morehouse, who was here with us today. Without objection, made a part of the record. Thank you very much. Hearing is adjourned. Let me just add, Steny Hoyer, without objection, he too, a statement that he has made will be made a part of the record as well.